Good afternoon, everybody. Welcome. Thanks for joining us. We are here today to discuss Tuesday's oral argument in the cases involving President Trump's tax returns. And joining me to discuss the cases, once again, is Stephen Mazie from Bard Early Colleges and The Economist. Stephen, thanks for joining us.
Thanks so much for having me back, Amy. Good to see you.
Let's go ahead and get started. We're going to take a look back with a quick review at sort of who's who in the cases and what's going on.
Okay, so I'll talk a little bit about the cases and then discuss in general what the purpose of an oral argument is before we look at the details of the way.
All right, can I interrupt you for just 1 second? One thing I forgot to do before we move on to the review of the cases. If you have questions, we're going to try and save about 10 minutes at the end of the webinar so that we can answer your questions. So you can use the chat feature to ask questions, or you can email your questions if you are not using if you're not in the live stream, but you want to watch and email your questions to feedback@scotusblog.com. All right, go ahead, Stephen. Sorry.
Okay, great. There's President Trump. The two cases heard on Tuesday both have to do with getting access to President Trump's tax returns and other financial documents, bank loans, payments, his balance sheets, those kinds of things. The first case, Trump v. Mazars, involved congressional subpoenas from 3 House committees that are looking into things like foreign interference in the 2016 election, money laundering, the president's financial ties, and these 3 committees sought years of Mr. Trump's documents to try to get a handle on legislation they might want to craft or laws they might want to strengthen. The other case, Trump versus Vance, is about a New York prosecutor's subpoena for very similar documents in a criminal grand jury inquiry that's looking into some payments to women that Mr. Trump is alleged to have made before the 2016 election that may have violated the law. So Cyrus Vance, who you see in that picture there, is interested in getting those documents to the grand jury so they can consider them, not to begin a prosecution of President Trump while he's in office, but to begin the investigation. Any indictment or prosecution would have to wait until he's out of office. So Mr. Trump did not appear in court himself. He had a personal lawyer arguing for him, a different lawyer in each case, and he had the support of a government lawyer in each case. So he was represented in his personal capacity, and you could say the presidency was also represented by a Department of Justice lawyer. If you listened in, and I hope you were able to, you may have been a little puzzled by what you were hearing if this is your first oral argument. Legal dramas on TV and in the movies rarely depict oral arguments. Usually what you'll see on those shows are dramatic testimony, cross-examination of witnesses, jurors looking on, looking confused, lawyers making impassioned closing statements to the jury, that kind of thing, and then a verdict. That's how things look at a trial court. If you lose at the trial level, whether it's a civil or a criminal case, you can appeal to the next level, to an appeals court, where generally there's no new evidence presented. There are no witnesses, there's no jury. It's just judges and lawyers talking. And that's what you heard on Tuesday if you tuned in. What is the purpose of this? What is the purpose of an oral argument? It depends who you are. If you are a member of the public or a journalist, you're interested in finding out about the case. So it's a good way to do that. It's a good way to look for clues as to what's on the justices' minds, who seems inclined to vote one way or the other, and how the case is likely to come out. For the lawyers arguing these cases, the oral argument gives you a chance to make your very best final case for your side, to distill all of the arguments in all the written briefs over months and months down to a few essential points, and to persuade the judges you're right and that you should win. For the judges, I think this is where it gets more complicated, and there are a lot of different purposes that the oral argument might serve. First, the oral argument gives judges a chance to focus on exactly what's bothering them about a case, to press on weak points on either side's case, and to see how the lawyers can shore up those weaker points. So that's one. Second purpose of the oral argument for a judge is to speak to colleagues, to speak to, if we're talking about a multi-judge panel, which the Supreme Court always is, and lower circuit courts also have 3-judge panels, if not larger. You're not speaking directly to your colleagues, but you're asking questions of the lawyers to try to communicate something which may draw one of your colleagues to your side, to your way of seeing things. Some justices do this more than others. Justice Kagan, I think, is acknowledged to be someone who does a lot of that in presenting not just her own interests, but seeing how she can craft a coalition of justices onto her side through her questioning. The third purpose of an oral argument for the justices is, I think, the most important, but also the least apparent for people who don't watch or listen to lots of them. And that is to get help from the lawyers, to get assistance with how to write the opinion. Many of the justices have this concern. I think Justice Breyer is most transparent about it. He often says something like, now I've read your briefs, I've read the briefs of your friends on the other side, and what I would like to know is, what I would like you to tell me is, how do we write this opinion? What words do we use? And what he means by that was really on display on Tuesday, when many, if not all of the justices were pressing the lawyers to come up with a so-called limiting principle. So what's the standard for determining when a congressional subpoena for a president's records is okay and when it goes too far? The lawyers, just to sum up on this matter, the lawyers are there to win their case. The judges are there to decide a case. And the judges are often leaning on the lawyers to help them write an opinion which makes sense of a lot of different things. To make sense of precedents, the cases that have been decided before that bear on this case, how to decide this particular case, and what principle can be used to articulate a plausible structure for how the justices can resolve cases next year or next decade that bear on very similar questions. So the best lawyers will give not just good arguments for why they should win in this narrow instance. The justices are only partially concerned with that. They're more concerned with the precedent that they're laying down and how what they're writing today is going to affect cases coming down the road. So when it comes to Trump's tax cases, the public is concerned with, are we going to get to see Trump's taxes? What's the effect on the election going to be? Those might be some of the concerns of the justices, but I think their bigger concern is how the decisions they're going to be reaching in the next few weeks will affect the presidency and the relative powers of the president and Congress. These are the separation of powers issues that we discussed in the preview. And I think justices see themselves as standing at a certain point in history where they're laying down markers for what's coming next. And that's really their job and their most important duty. So maybe we can now turn to how the oral arguments went in these two cases.
Yes, that was a fantastic summary. So the arguments that the president's lawyer made in the Supreme Court, talking about, sorry, I went forward by accident, talking about the efforts by Congress to get his tax returns. His lawyers argued that Congress should very rarely, almost never, essentially, be able to ask the president's banks, the president's accountants, or of course the president himself, to get the president's tax returns and the president's financial records. They have to be able to meet a very high bar before they can do so. There was a lot of discussion in both of the cases about the idea that the president has a lot going on. The president is a very busy person, and that there's a real concern about harassment of the president, taking time away from the president's duties if the president can be subject to these different requests all of the time. And so talking about the requests from Congress that that Congress can't make requests to the president the same way it can make requests to everyone else. And then talking about the request from the grand jury in New York, it's not even that there's a very high bar. The president's lawyer argued that a subpoena from a grand jury for the president's personal records can never be enforced while the president is in the White House. After the president has left the White House, yes, but not while the president is in the White House. Congress's argument was that there really isn't a higher bar for the president, that the request for the president's records can be enforced as long as the committees have what's called a legitimate legislative purpose, as long as the committees plan to use the information that they were going to get from these requests to draft new laws. And they say, we wanted this information from the president so that we could consider whether we wanted to make changes to ethics laws, so that we could conduct investigations into whether foreign countries like Russia had influenced the 2016 elections, so we could conduct investigations into money laundering. And that should be enough as far as we're concerned. The argument by Cyrus Vance, the New York district attorney, they said the president's not immune. He said, we'll agree to a higher standard. If the president can show in a court, he can go to court, he can show that complying with the request is going to interfere with his duties, then yes, maybe we do have to show more than we would normally show. We have to show that there's a good reason to have this investigation that involves the president, and that there's a good reason, there's a good chance that the subpoena is going to lead to information that is going to be useful to the investigation. So we'll concede that maybe we have to show more than we would for a normal grand jury investigation, but the president is not above the law. All right, Stephen, what did the justices think? And let's start with, I think it's important for these two cases to separate them, because I think that the justices' reactions were different, at least to me, in the two different cases. So let's start with Congress.
What you're about to hear is a version of what we all, after a case is heard and the reporters are filing out of the courtroom and we're walking down the stairs, we're chatting with each other about what did the justices think? What do you think the outcome is going to be? We haven't had a chance to do that with these virtual sessions where we're not in person with each other. So we get to do it here with you openly.
Yes, exactly.
Yeah, I do miss that press room banter where we develop ideas together, but here we are, we're doing it a different way. So with the congressional cases, I think that the lawyer for the House, Douglas Letter, was a bit taken aback by how many questions he got as to what the limiting principle on congressional subpoenas should be. I think it sounded like he walked into the hearing, or he dialed into the hearing, assuming that the justices were on board with a long line of precedent that says that Congress basically can subpoena documents that it wants. If it has any conceivable legislative purpose, then it can ask for documents. And this is a rather unfettered power that Congress has. So I think he was starting with that assumption, but the justices clearly weren't. They were interested in finding out from Douglas Letter, well, as I mentioned earlier, what type of subpoena goes too far? Can you ask for medical records from a president if you're crafting healthcare legislation, right? That seems like a pretty tenuous connection. And I think his answer to that was no, but he didn't have a real clear standard he could provide the justices. And this was particularly clear when Justice Alito drilled down on him about halfway through his presentation. If you don't have any example of a subpoena that's not acceptable, then what limits on Congress are, what are some plausible limits on Congress? You haven't given us any. So there's a worry among the lawyers for President Trump, and apparently among many of the justices, that there is a risk that Congress could end up harassing presidents and undermining the work they do by requesting too much of them.
Yeah, I think there was a concern about, I think the word was what you might call a fishing expedition, that Congress can go looking for any kind of information, and they can sort of, as some of the justices suggested, tie it to something that they might someday want to write a law about.
Right. And I think that sort of underlying that is some skepticism that maybe they're not interested in writing any laws about any of this, but maybe it's just about exposing the president's records for the sake of exposing them. That's at least what some of the justices seem to be worried about.
Yes, I think that's right. And so the flip side of that, let's move on to the New York case. And to me, it seemed there like the same concerns about wanting to avoid some sort of, absolute bright black and white rule came into effect, but this time it worked against the president rather than for the president.
I think that's right also. Jay Sekulow, the lawyer for President Trump, who had more of the time and who introduced the argument, just presented a very clear and, as I put it in the article I wrote, almost royalist view of who the president is. He says the president is the executive branch. The president is absolutely immune from any criminal process, not just prosecution, but any criminal process while he's president. Only after he leaves office can anything like this happen. And when he was asked questions by Justice Kagan and others as to how this is consistent, and Justice Ginsburg, how this is consistent with the idea that every man has to provide evidence, and that no one's above the law, the response from Mr. Sekulow, he just didn't seem to acknowledge that presidents being above the law is a potential problem. He was only concerned with showing that presidents are special, they're not ordinary people, and different rules apply. And I don't think that he convinced very many, if any, justices that that is the right approach to take.
And I think it was helpful, to the district attorney's case that he was willing to say, maybe we do have to meet a higher standard. We can't send the president a request for whatever we want, the same way we would with a normal person. So it seemed to me, coming out after that oral argument, that the president is not likely that the president is likely to, let me start over again. It seemed that the president is probably not going to win in that case, that the Supreme Court in that case is going to say that at the very least, the president may have to produce his papers to the grand jury, and there may be a higher standard, and we may have to have more litigation about whether or not that higher standard is met, but that the Supreme Court is not going to say the president never has to produce his papers to a grand jury.
I would sign on to that prediction. I'd also say that the main precedent at stake in this case is Clinton versus Jones, the 1997 case, which involved a different type of prosecution, and it was a civil case involving President Clinton, who was claiming he was immune from and should not have to sit for any depositions in a sexual harassment lawsuit that a woman was bringing against him. And the Supreme Court said 9-0, no, I'm sorry, you do. You can't be overly burdened while in office. Presidents have a lot to do and their schedules are tight and they're the leader of the free world and all that, but presidents aren't above the law either. So you need to sit for depositions. So in that case, the court ruled that presidents are not immune, and it would seem inconsistent to say here that they are. The two distinctions that the lawyers, both Sekulow and Noel Francisco from the DOJ were making are that, well, this is a criminal case, not a civil case, and it's a state case, not a federal case. They kept repeating those differences without, I think, stating what the real distinctions are between state, federal, criminal, civil. One of the arguments on criminal versus civil was, well, there's a much greater stigma on a president to have a criminal case proceed while he's in office, as opposed to a civil one. The answer from Carrie Dunn, the lawyer for Cyrus Vance, I think was persuasive on that. The stigma associated with a president being accused of sexual harassment is pretty high and might match that of a criminal process. And the state versus federal question, I don't know if you want to talk about that one, Amy, if you think if there's a distinction there that the lawyers were successfully trying to paint.
Yeah, let's move on. Yeah, I think we want to leave time for questions, so maybe we'll move on and see. We've got some questions in the queue. Let's see, we've got a couple of
One of the questions actually piggybacks, I think, on the point I was just making.
Yes.
There's one person who's saying that one argument seemed to be in the Vance case that it was harassment because New York copied the House subpoena. And so this is a point that was brought up, that clearly it's there's some sort of collusion going on between the House of Representatives and the New York City prosecutor if the language of the subpoenas looks identical and Cyrus Vance copied from the House. Do you think that suggests that there's harassment going on the part of the New York prosecutor?
I think that actually the answer was that the subpoena was going to the same institution. It was going to the same accountants. And my recollection, and Steve, you can correct me if I'm wrong, was that the district attorney from New York said, we were actually doing this to try and be helpful to the accountants to save them work, to make it less burdensome for them. So yeah, people obviously can judge for themselves what the significance of that is, but there was an explanation of why they did that.
Yes, but there was another aspect of the harassment argument that Mr. Trump's lawyers made, which is that if you allow this criminal process in New York City to go on, what's to prevent 2,300 prosecutors from all over the country to, subpoena the president's records for potential prosecutions in their districts and in their jurisdictions? What did you think the justice's response to that, or do you think the justices will be worried about that in the way that Francisco and Seculo want them to be?
I think that they are. I think that it is a data point. I don't think it's necessarily going to change anyone's mind. I think that the sort of absolute point that the president's lawyer was making in the New York case just didn't seem to fly very well with a majority of the justices. I think that the real question in the New York case is what kind of higher standard the justices ultimately adopt. And the federal government, which was supporting the president, but wasn't advocating for the same kind of black and white, the president can never be the subject of a grand jury subpoena while he's in office position, was also arguing for a higher standard like the New York district attorney, but a different higher standard. And so I think it's just a question of which kind of higher standard they choose. And I'm not sure that this argument that they copied the House subpoena really factors into it.
Should we take another question from the chat here?
Sure. Do you have a preference? I think we addressed one of them, which is what happens if the Supreme Court does? I think this is a good question. I want to. What happens if the Supreme Court decides to send the case back to a lower court? Which I think is actually, I think there's a good chance that that could happen in both cases. I think there's a very good chance that that will happen in the case involving Congress's subpoenas. The Supreme Court could say that the lower courts didn't look, the lower courts looked at whether or not these subpoenas had a legitimate legislative purpose. They need, because the president is involved, to undertake a more searching review. And so let's go ahead and do that. In the New York grand jury case, they could also say, because the president is involved, we need to undertake a more searching review. They could say, theoretically, a more searching review is required in the New York case, and that test has been met. I'm a little skeptical about whether or not that will happen. Either way, I think what's going to happen is the cases could get kicked back down to the lower courts, and nothing will happen one way or the other until well after the 2020 election. And also you have to remember that even in the New York grand jury case, even if there is a court that ultimately says, okay, these subpoenas are legitimate, Mazars, the accountants and the banks can turn over the subpoena, the information that's requested, then it gets turned over to a grand jury and it's still secret. So that doesn't mean that the information in the president's tax returns would see the light of day publicly anytime soon.
Right. So Americans who are interested in seeing Trump's tax returns and other financial documents are probably, I think we're in agreement, are probably going to be disappointed in the short run. It's unlikely that these tax returns will become public, will be published in the newspapers before the election, and maybe before Mr. Trump leaves office, whenever that is, whether it's next January or 4 years later. But there was one moment in the Vance argument where Justice Alito seemed to worry that if Vance wins, and that if the subpoena is enforced, and if Mazars and the banks turn over the information to the grand jury, that even though grand juries are supposed to keep information secret, that maybe those documents might leak. And he mentioned the New York Times as a possible source, as a venue where those documents could be leaked. Amy, I was curious what you made of Justice Alito's worry with regard to that issue.
Yeah, I wasn't quite sure, I think, where he was sort of where he was coming from, or what the point of that question was, but certainly I think that I guess his concern was, even if the documents were turned over to the grand jury, they could still be disclosed publicly, I guess. Here's another question, just like another good question, just like the Justice Department's reluctance to get involved in politically charged cases right before an election, does the Supreme Court also have a similar reluctance? Yes, I think is the answer to that question. We saw that in, for example, the Obamacare cases back in 2012, when they decided about healthcare during the middle of the 2012 presidential election. And I think that is certainly something that many of them, not all of them necessarily, but many of them are thinking about in the backs of their heads as they're deciding this. And I do think that is another way that sort of the outcome of these cases, if it happens the way that Steve and I think it could, is a way that would make the Supreme Court look sort of relatively apolitical or neutral. If in the congressional case they sort of hand Trump a victory, but in the New York case they sort of hand him a defeat, and in the end nobody knows whether or not he's going to have to turn the documents over until after the 2020 elections. I think that would probably be an outcome that many of them on the court would like, frankly.
Yes, I think Chief Justice Roberts is probably the most interested in lowering the already very high profile of his court, and dialing down the politicization that seems to be forming around the court more and more. in the last few years, and with regard to all the other big cases that are set to be decided in the next few weeks about abortion access and gay and lesbian rights in the workplace and DACA and church and state. We were talking about a whole bunch of them. To issue a kind of split decision, as you suggest, Amy, and even with that split decision, to kind of give President Trump relief from having his records exposed to the public before the election, that might be not just the legally correct in their view outcome, but one that makes them seem more like a fair arbiter of these very contentious questions between Democrats and Republicans, between the Congress and the president, and to assure people that the Supreme Court is keeping its eye, as I mentioned earlier, on history and on what's coming in the future, and not so focused on who wins political points or who loses them after a particular case is resolved.
All right. Well, I think that is all we have time for today. Thanks, Steve. And thank you, all of us, for joining us. We have another webinar at this time tomorrow on the faithless electors case. So hope you'll join us then. Take care, everyone. Stay safe. Have a good day.